everybody, and welcome to yet another edition of the Middle Georgia Spotlight. I'm your host, Jack Ellis. Thank you so much for joining us. In the Spotlight this week, he's no stranger to this program and no stranger to people in the media here in Macon and Bibb County. We're speaking none other than Dave Oedel, who is a law professor, constitutional law professor at, I think, the Walter F. George School of Law here at Mercer University. Welcome to our program.
Great to be here, Jack.
Well, you are here at a time when so much is going on from a legal standpoint that some people like myself and other laymen would like to know your position, not just your personal position, but the legal position on it. Yesterday we had what a lot of people are calling a landmark case. When I say yesterday, we're taping here on the 21st of April. Yesterday, the 20th of April, a police officer was found guilty on 3 charges of manslaughter and some other charges. How rare is that?
I'm not sure, Jack, is specifically how rare it is that a police officer is given a murder charge for excessive force. It's got to be very rare. But this was an unusual case, and the kinds of charges that were lodged against this man, Chauvin, in Minnesota were charges that included manslaughter, but also were 2 types of murder, not intentional murder. And that was one of the interesting things about the charges. None of the charges required that the prosecution show that the individual officer intended to kill the individual. So that made it a much easier case for the prosecution to show that he did things that resulted in the death of this individual, and it was, it was a fairly clear case that there was a very unusual procedure that was undergone, and everybody could see it. And so one of the unusual things is that we could see obviously the video for 8-9 minutes, and that made a huge difference in the case. There was really no ambiguity after a little bit that the guy was really just out of it and begging for his life. And the fact that this individual did not show any mercy, I think, was going to mean maybe he didn't mean to kill him, but he certainly didn't want to give him any mercy. And so I think the charge was of a kind that didn't require the intent, and therefore the verdict was swift and strong.
Well, now he still has a right of appeal, but there are 3 other police officers that's going to be charged, I understand, going to go on to trial in August for aided and abetted this. So how to explain the aided and abetted? But just standing around not doing anything?
Well, that's an interesting question, and I think that they're going to have a hard time trying to overcome the notion that they're, especially later in the process of holding them down, that they didn't act more aggressively. I mean, that's a problem. When they had the EMT come in at the end and say, hey, listen, you got to get this guy Chauvin off of him. Get him off. And for this outsider to have to come in and make a statement would suggest that these officers were really out of line for not intervening with Chauvin. And the guy now who's known to have been convicted of murder. Now, it's true that he's got appellate grounds, but it's going to be hard to see that anybody's going to want to mess with this particular one, especially given the fact that the jury was so emphatic about it. And so I do think those guys are going to settle. I think they're going to plead.
Yeah, but now you have sentencing. I understand that's going to come in June. But he didn't want, I understand his attorneys did not want the jury to pronounce the sentence. They wanted the judge to pronounce what the sentence would be. What's the difference in the jury saying we and say we'll let the judge decide?
That's often an interesting question for people to have in that situation. Who do you want calling the shot? And I think they often will believe that when there's an inflammatory situation, that a jury would be more likely to throw the book at the individual, rather the one that's highly in the public eye, rather than a judge who's kind of trained to be a little bit immune to the public outcry or something. So he's presumably hoping that the judge would give him a less vigorous or robust sentence. Fact of the matter is, though, that even the judge's hands are going to be really tied in a situation like this. He's going to go away for a very long time, and possibly even for the rest of his life.
Now, You know, constitutionally, we all have constitutional rights, even when we are arrested. You have to read your rights, and people have to be treated with, I guess, somewhat respect. They should.
Sure.
Now, how was his constitutional rights violated? The manslaughter charge, we know, was it, they denied him his First Amendment, not First Amendment rights, but the right of what?
Well, he has a right to be under the, for instance, in the Fourth Amendment, you can't be unreasonably searched and seized, and you know the question of reasonableness is up there. I mean, was this a reasonable thing to do? Clearly, his constitutional rights were violated, and that's why the civil case was settled by the city of Minneapolis for $27 million. So it was clear that this was over-policing and overly aggressive policing. So clearly, under the Constitution, his constitutional rights were violated. Not just the state tort, but his constitutional rights to have liberty and freedom in your person and not to be treated by an officer, even in the course of an arrest, in an overly aggressive manner, which this clearly was.
Now, this has led to a call for police reform all over the nation. This was an international case. When I was overseas, people were talking about George Floyd. What does police reform look like? And I mean, these guys and ladies, they have a gun, they have a badge, they have a charge to go out and do certain things. But what does police reform look like? We change the behavior, attitudes, procedures. What does police reform?
Well, that's an interesting question for you to answer, Jack, because you were a mayor, you were supervising a police force, and I'd be interested in what you would say that would be warranted for reforming police. Do you think reform is warranted in a place like Macon, Georgia, for instance, which you know quite intimately?
I think it is. I won't go into that, but I think there's room for improvement in every department, be it in public works, be it the police department, wherever, but especially in the police department. And I think that's where people like you, a lawyer, a professor of the Constitution, should go in. I don't think our law enforcement officials are trained enough to know exactly, I think they go up to that line, but it's best to always err on the line, on the side of caution, unless your life is in danger. I don't think anyone want to put a police life in danger and say they should, turn their back if someone have a knife or gun on them. But sometimes this overly aggressive policing, I think we can do something about that.
One of the big issues legally on this question in general is the extent to which the qualified immunity should be narrowed of officers in the course of their duties. And so what they do right now is they get a very generous amount of leeway legally after there's a question about what they did and are they going to be protected from civil suits after they do something kind of that looks wrong, basically. Yeah. And the question has traditionally been, unless it was a very clearly established constitutional right and they knew they were doing something bad, you're going to be free. But now people are talking about, hey, maybe we should revise those laws in such a way to make it cabin them, make them narrower. And
well, all politics are local, so probably all law enforcement is local because it's controlled locally. We don't have anything like in some countries you have a national police force. We have all local police force. So let's talk about our local police force. Been in the news a lot lately. One, that we had overcrowding in the jail where we have young men sleeping on top of each other on the floor in the middle of a COVID outbreak, and that came to the public. How do we deal with, if it's overcrowded, is it time to let people out of jail if they're not there for serious crimes and let them wait to go to court out rather than warehousing them, stacking them on top of each other, violating possibly their constitutional rights?
Well, I'm working with a case right now involving a young man here, probably shouldn't say his name, but he's been in jail for years without any charges being brought against him. And I do think that there are situations where people are in jail that they should either get a trial or they should get out. And so you have to look at it case by case. But I think you're asking, sort of broadly, systematically, should we release
Non-violent, I'm speaking of non-violent
well,
offenders.
yeah, that's
Probation violators.
The people have talked about that. Certainly, that has been a position of our prior governor. He really put a lot of his governorship for 2 terms on this question of trying to spring people from jail who really shouldn't be there, and the mass incarceration thing. And he worked very hard on that.
Yeah.
And that, I think, was a very successful program, and I think we can continue to do that and do more of it. But at the same time, we also have a situation here in Macon where we're having a very large increase in murders, violent crimes, and so we have to watch out there. We don't want to give the signal to the people with guns that are shooting one another.
I'm not talking about letting those people out.
I know.
I'm talking about letting someone out, maybe got caught with less than an ounce of marijuana, and he violated his probation. Now we're going to stick him here until he can go to court.
Yeah.
And the courts already said we're not even going to have court for a whole year because of COVID.
Right. Well, certainly that's an easy case. You don't want to be putting people away for that. But my understanding is that our police department is not putting people away for minor offenses.
But for probation violation, that's what's happening. A lot of people have already been charged on probation, then they get stopped again, and so you violate your probation, so then you get scooped up and you get thrown in the poker. But that's maybe a story for another time. But before we leave the law enforcement and get to something, and here again, locally, recently we had a deputy, and my heart goes out to the family of the deputy that was murdered by an inmate. But the question begs to be answered, and as far as I'm concerned, when I was, as you said, I supervised a police department, hired 2 police chiefs, fired another one. My question would be, why did they have a knife in that area, secure area? It's not part of the uniform. It's not issued. It's not an issued item like a gun or a taser, handcuffs that we issue officers. Why was a knife there? Who knew it was there? When did they know it was there? And what did they do about it? That would be my question.
That's a good question, Jack. And if you think about it, if there's a rule against these correctional officials having weapons themselves on their person while they're working with prisoners, if there's a good reason for that rule should have applied in the situation where the deputy was with the prisoner and he had a knife. And if that was accepted as policy in the jail, then you have to ask yourself, well, why did they have that other policy that says they shouldn't have it? So which is the policy, and which policy makes sense? Now, maybe circumstances where you do want to have weapons, but in any event, apparently the rule was no weapons.
Included a
and
knife.
if the rule is no weapons, then what was the knife doing there? I think you're exactly right about that.
Because with the gun, you've been trained. You go to the range, you're taught but who trained this guy how to use a knife? Or any officer with a knife? How were they trained? Why did they get a knife? So that's something I think the public and the community has a right to know, and I want to know just as a citizen, but especially as a former mayor, I'd like to know that question. But let's move beyond that. But now we see, as a result of that, the sheriff said, I need $3 million right now to fix locks on an emergency basis. But yet they said, well, the lock's been like that since the jail was built. So it can't be an emergency if it's been that way since the jail was built. That means either the contractor or the architect, whoever was in charge, to fix it, or it's not an emergency. I mean, that's
your rationale. I think you could
one.
make a case that once you are aware all of a sudden that there are serious problems with your security purposes, that it may be an emergency because you didn't
But they said
recognize
they knew about it all the time.
Well,
it's been that way.
That's an interesting point, but it still may be an emergency today to kind of clean things up if we recognize that we have a problem.
Well, let's get back to, again, politics. The biggest thing politically that's happening, of course, next year we have a governor's race, and we just had the big race here. But politically, what's happening, the voter law. House Bill 202 or Senate Bill?
Senate Bill 202.
Senate Bill 202. How has that bill been characterized, in your opinion? Has it been characterized fairly, unfairly, or justifiably criticized?
I think it's been unfairly characterized. From what I was hearing, I have it right here with me. I have the full bill. You can read it. But I was reading a bill that I was hearing about on the news that just didn't line up. Even when the president was describing what was going on with respect to this bill, I was thinking, you're not reading the same bill I'm reading. So I think they really mischaracterized the bill in many respects. And for instance, there are 17 days allowed for prior voting, and that's more than, you know, kind of most states around. And there are just the really contentious issues were around the absentee voting and whether there should be voter ID or more improved voter ID for that. And that seemed to me to be a reasonable compromise that they had reached on how to do that. And so I think that the bill was oversold as problematic. And I think that the one issue that people really glommed onto just has it was the water issue, and you know that's kind of it's symbolic, I suppose, but it's really is a practical matter, not a real issue in the sense that if it is hot, then the poll workers can supply water, and if that's in the law, and it had always been illegal to have campaigns and stuff, people
within that
distributing
150 feet.
within the 150 feet. And that's still the case. That's no different now than it was before. So really they're just continuing with the provision that we'd always had.
Well, I'm going to call it the C. Jack Ellis law because you represented me unofficially, but you gave me counsel. I didn't pay you. I didn't pay him, but I was hauled before Secretary of State Kemp for handing out water. Giving water. I didn't give water to a voter. I gave water to a person who gave water. My name wasn't on the bottle. It wasn't C. Jack Ellis water. It was water from Kroger or some other grocery store. But yet I was called up there, and I had to plead whether I was guilty or not. Of course, I was guilty as charged, and I said I was. But now they've codified it, so now if I was doing that, they would have probably threw me in the pokey, I guess. Could have.
I think the rule had always been in effect that you couldn't campaign within 150 feet. I think the issue in your case was whether you had an agent who was campaigning and was the agent of the campaign.
Wasn't campaigning. We were passing out water to people on the hottest day in Macon.
Yeah, no, I understand the thing. But again, what this law does is it actually says that we didn't have before. It points out that adds this thing that the water can be distributed to these people in mind. The other thing that they also did was that if you're waiting more than an hour, then there is a problem with that voting precinct, and there's procedures in place to deal with that going forward. But the water issue was a big issue, and it wasn't interesting. And in the end, in your case, it went to the Attorney General, and at that level, that's when I kind of got involved after you had been at a lower level. And at the Attorney General's level, that case was thrown out against you.
Yeah. Now, let's get about the drop boxes. Even though the drop boxes were new, but they were beneficial. They're very beneficial, I understand. So now they're taking them out and say they can only be in a polling place and only during the hours of the polling place, the operation of the polling, which doesn't make any sense to me. Why wouldn't we have drop boxes? Why wouldn't we want to make it easier for people to drop off of an absentee ballot, a ballot that they've already cast that ballot, and if it's a secure box, why would we want to make that difficult?
Well, I think that the suspicion is that the drop boxes were used to pack the ballot box, stuff the ballot box out of sight of authorities, and so putting it in the polling place, the notion is at least that you get rid of that specter of there being unreasonable packing of the ballot boxes. But
my point is, if it's in the polling place, just drop it off at the count. Why even? But anyway, we're moving. But the one that a lot of African American, let's say Democratic cities, which happens to be controlled, the larger ones anyway, Atlanta, Fulton, DeKalb, Augusta, Savannah, Albany, Macon to a less Macon as well. And that is that provision they put in there that we can take over an election board at the state, the legislature, and they don't say what they have to do, that they can come in, if they don't like the way that election board is conducting themselves, they can come in and take over and change the results of maybe how the votes were. That is blatant, in my opinion, an overreach on the part of the legislature.
That is a contentious matter, and it's good to bring it up because that has gotten a lot of people's attention. There's been a lot of ire about that. We have had some example of that before in the school board situation where the governor has this power to kind of step in a failing school situation and kind of push the school board aside in individual communities. It's occasionally been used, so that was the model for this. And yes, it's an end run around local control. I mean, we have long been a state that has been very interested in local control, and this cuts the other way.
Now, your day job, of course, as I said earlier, you are a law professor of constitutional law at the West F. Georgia School of Law at Mercer University. How has COVID changed your teaching method or the learning method of the students? Have you all, over the last year, have you been in place? Or you been learning, teaching virtually?
We've had some of both, Jack. We've had some people, some of the time we're with people in person, and I'm in person with anybody who wants to be in person. So except for a brief period last spring, a year ago, when we were required to be out. But Mercer went back for this entire school year, and with the option of being live, and so a lot of students are live, and other students are accommodated by being able to be remote. So we have camera going at the same time that we're in the live classroom, and we're zooming in with people, and we've gotten better at the technology as we've gone along in this year, so we've improved that. We're finding actually some advantages to the Zoom kind of device and doing that, and in some settings it can work really well.
Now, Willie, like in high schools or some colleges, and we're going to give maybe the fudge factor because maybe we'll give a point. Will this be taken into consideration, not necessarily how you're going to grade, but when these young people get ready to take the bar, will that be taken into consideration that we maybe didn't get all that we were supposed to give them, or everything is
according
still the same?
to taking the bar exam, there's no dispensation for that. You either pass that or you don't. So,
but are you given any credit for?
Well,
I mean,
we do have to do things a little differently. So, for instance, in an exam I'm giving now, ordinarily that exam would be in person, but I'm going to allow that exam to be given remotely. So we're going to do that by, people can sit at their home computer and just tap out their exam.
So this will be on the honor system, so to speak.
Well, there are ways to check it, yeah, but they have elaborate and improving protocols to check what people are doing. In my particular exam, you can't really cheat on it, so there's no, I don't really need to worry about it.
Oh, okay, so it doesn't matter.
It really doesn't matter. They're going to have to, they've only got a limited amount of time, and they've just got to march through these questions, and they have 3 hours and 15 minutes, and there you go.
Well, let me ask you a personal question. You're over 60. You don't look like it. You don't look it, but you're over 60. How have you gotten a vaccination and a vaccination? And how the young people that you interact with every day, are you all wearing masks in class because they are not getting vaccines, but you have? How are you dealing with that?
Mercer does require that we have masks in the classroom. I've taken the vaccine. Everybody in my household, we have 5 people in our household, including an exchange student, but we have all taken the vaccine, and so we're ready to roll, and we honor the situation where we're in a public place where they don't want you to be without a mask, and we'll do that, but otherwise we're pretty much living maskless.
Yeah. Well, Dave, you have been in this community for, 30 years now, 30 plus years.
Yes.
So you know Macon pretty well, and you probably know its history. We have had a very divided, when I say divided, of course, we had a very segregated city until like 1970, the schools were segregated. I have asked you, I want to be on record, I've asked you to look at and help advise me and other African American veterans, and I want to say this publicly, that we're approaching Memorial Day. And what advice you're going to give us, I don't know, but we've asked you to look at our situation because we were denied entry to Lanier High School where we could have gotten ROTC, which meant that we could have entered the armed services at a higher rate, but we were denied that because of segregation, even up to 64, 65, that we were still denied. Do we have, can we move forward?
I certainly think that you can move forward with an administrative complaint with the Army. Let's just sketch out a little bit of your story, Jack. It's a very interesting one. Beginning in 1917, during the First World War, Lanier, all-white high school for young men, began a program with the Army where basically all the students at Lanier would be involved in junior ROTC.
All white, all male.
All white, all male, and then that program continued throughout this entire period up until, and actually, I'm not sure when they ended that program as a requirement. Late 60s. But
after the Voting Rights Act, after the Supreme Court, Board of Education, after the Army integrated in 48.
Right, and you were at Ballard Hudson High School and not allowed to go to Lanier. You ended up actually enlisting and then having a career in the military, in the Army, and yet you were not allowed to participate in this wonderful program, really, at Lanier.
Very wonderful.
Permitted
one of the
these
best
people
in the nation.
Permitted people to move up the ranks earlier as in officer roles, and that was a thing that was denied to you when you graduated, I believe, in 1964.
Would have been my class, yeah.
And you enlisted in the Army in 1963.
Yes.
And I mean, it was just a.
All these guys were drafted, like me. They were, a lot of them were drafted. 6 went to Vietnam, but yet they didn't have the benefit of junior ROTC, which meant they made less money than our young white counterparts here in the same city, going in the Army doing the same job.
That's right. And you were, people talk about reparations and stuff like this, but a lot of that stuff is, really water under the bridge, in my view, to some extent. I mean, we're talking about things that happened a long time before anybody was alive today. But we're talking right today with a person, you, Jack, who actually experienced this, and you're experiencing a continuing harm in a way when we're talking about the fact that your retirement income from the military after your career, successful career in the military, is lower than it would have been had you been able to be
attend ROTC.
Yeah, attend
because
this
I would have went
wonderful
in with a higher
Lanier
grade,
program.
and I would have moved high.
Yeah.
Let me tell you the strangest thing, Dave, and we're about 30 seconds left, but we thank you all for sharing with us in this conversation. My very first commanding officer in the military, I was overseas. My very first commanding officer was a graduate of Lanier High School at Mercer University, a guy named Captain Arthur L. Rich Jr. His father had been a music professor, but he wasn't Lanier, but he was recruited from Lanier to get an ROTC scholarship at Mercer, so that's how Lanier was. But the unique thing about Lanier, they were all active duty Army officers assigned there by the Army. So that's why we think we have occasion. We thank you for giving us an opportunity, and thank you for sharing with us your perspective on the trial that just happened, the voting rights, among other things. Dave Oedel, law professor, Mercer University, Worth F. George School of Law. Thank you all so much for joining us till next week. Goodbye.